It still says Carter on my calendar. I know that's not correct.
It's Eric Eisenberg.
Eisenberg. I apologize, Mr. Eisenberg. But it shows that Glenn Carter represents Lewis County.
I understand.
Okay.
I know that we did a substitution. I don't know why it's not reflected, but it doesn't bother me.
Okay. Last week I heard a hearing in this matter, and I denied Mr. Hupy's motion to strike the answer of the defendant. Mr. Thomas then indicated that he wished to appeal the court's denial of the motion to strike the answer, and we then had a brief interchange about that and whether or not an order should be entered that clearly indicated what the issue was. I would indicate that I believe that I was unclear what Mr. Thomas was requesting of the court at the last hearing, and I want to clarify that today before obviously we go too far into this hearing. And the reason I indicate that is that I did not have in front of me, or was certainly not reviewing the rules of appellate procedure at the time that Mr. Thomas indicated that he wanted to file an interlocutory appeal. Parties have the right to file those for different reasons. And so when Mr. Thomas was using the term that he wanted the court to certify the issue, I was interpreting that perhaps incorrectly. I believe that he wanted it clarified by way of an order so that the Court of Appeals would be really clear at what the issue was that he wanted to appeal on behalf of Mr. Hupy. So in preparation for today, so I could ensure that the record would be clear, I reviewed the Rules of Appellate Procedure 2.3, decisions of the trial court which may be reviewed by discretionary review. And in reading that, that is when I believe that perhaps I misunderstood what Mr. Thomas was asking. And so Mr. Thomas, I wanted to start out by asking if what you were requesting is that I certify pursuant to Rules of Appellate Procedure 2.3 subsection 4, if that was what you were asking the court to do.
Yes, Your Honor, and if I may approach, this may help. I have a draft of an order.
All right, thank you. I'll take a moment to review that. Mr. Thomas, in looking at the rule, it indicates that the court can certify that the order involves a controlling question of law as to which there is substantial grounds for a difference of opinion, and that immediate review of the order may materially advance the ultimate termination of the litigation. And when I read that, and then believed that perhaps that was what you had been requesting, and I apologize that I misunderstood the issue last week. How is this, the very few cases that I have seen that have been certified to the Court of Appeals involve a substantial legal issue that really could have statewide implications, and I don't see how this falls into that category. I mean, the Court of Appeals only wants an issue certified to them in the middle of a case when it is a big issue, a really contested legal issue, not just a difference of opinion that you don't agree with what I ruled, because you have the ability to appeal, try and appeal that and ask for discretionary review because you don't agree with what I did, which is perfectly fine. I'm just wondering how this particular issue could possibly rise to the level of the Court of Appeals really wanting to get a certification of this issue. And again, I apologize that, I believe I clearly misunderstood what we were discussing at the very end of the hearing last week. So why don't you go ahead and address that for me, please?
Well, thank you, Your Honor. I'd be happy to. So in the filing, actually, Mr. Hupy argues that if the answer was not stricken, it would be a violation of, one, his procedural due process rights, and we listed it out under the United States Constitution, and I believe under the Washington State Constitution as well, and his right of access to the court, which is another fundamental right protected by the United States Constitution and under the Washington State Constitution, and that's listed here in the order. And I think that most people would agree, and reasonable people would agree, that constitutional issues that guarantee the right of due process and procedural due process or right of access to the court would be issues of public import or broad issues that would be applicable to people across the state.
All right, thank you. Mr. Eisenberg, last week you objected to the appeal issue, and perhaps you were specifically objecting to the court certifying the issue. I'm not certain. Do you have any response?
Thank you, Your Honor. So I was objecting to the court certifying the issue, and the reason being that even though the type of constitutional claims that Mr. Thomas has articulated on behalf of his client are important and obviously worthy of being considered by the court, there's a strong preference for such issues to be considered in a single appeal that follows the end of the case, because it's considered to be more efficient and just on the whole to have the case proceed, get finished in full, and then be heard on appeal in full, than to interrupt the progress of the case and have it go up in the middle and then come back. The reason that in this case makes sense is that there are certain legal grounds that Lewis County raised on which it could prevail that would render the types of issues that Mr. Thomas has raised moot. Specifically, he was concerned about defenses, particularly factual defenses on which he could have sought discovery, that were raised in the answer. But if it so happened that instead the court ruled on a legal grounds that was mentioned, for example, in the motion to dismiss, and so notice was provided, and legal grounds can be raised at the trial as well, that might render some of Mr. Thomas's constitutional issues irrelevant because the answer would not have been consequential to the case. So it would be more efficient, I believe, and just to not certify the matter for appeal. However, if Your Honor disagrees and feels that that is important, I was prepared to accept that ruling from last week, so I'm just stating my position now to avoid any potential waiver if Your Honor does do that. Thank you.
All right, thank you. Anything further, Mr. Thomas?
Yes, I would like to respond to that. So Mr. Hupy is indigent in this case, and he doesn't have the resources in order to go forward and then come back and then possibly correct those issues. And also, furthermore, Mr. Hupy can't go forward with this case because he doesn't know which mandatory court rules are really mandatory. CR 12A4A is a mandatory court rule. There's nothing that defendants have said that makes it permissive, and there's nothing from the ruling last week that makes it permissive. Furthermore, CR 8D is a mandatory court rule as well. Notice pleading is mandatory across the state. It goes to due process. And if these mandatory court, we need guidance from either this court or from the Court of Appeals on what mandatory court rules will be followed and which mandatory court rules will not be followed for due process in going forward in this case. So it's absolutely necessary that we have an appeal right now in order to determine how due process applies to mandatory court rules.
All right, thank you. So I do not believe that this is the type of legal issue that is anticipated by RAP 2.3 B4, and the court is not certifying that issue to the Court of Appeals. The court's denial of the motion to strike defendant's answer. If Mr. Hupy has another basis to request an interlocutory appeal, he certainly can pursue that. What I previously indicated was that the court was willing, before Mr. Thomas said that he wanted to appeal the issue, and I'm not saying he can't. I said that I would set the hearing over. I asked how long the hearing needed to be set over. If there needs to be discovery, as Mr. Thomas has indicated, because of facts that were unknown until the answer was filed, then the court would consider that. As it relates to Mr. Hupy being indigent, the interlocutory appeal would interrupt the proceeding. You have all the costs and fees associated with a civil appeal, for which oftentimes there are not the ability to access funds. It could come back down. The court could then rule based upon whatever the Court of Appeals said or didn't say. And then there could be another appeal. And in fact, then it would be more expensive for Mr. Hupy. And so I appreciate that Mr. Thomas has pointed out that he is indigent and that he is concerned about certainly the ability to fund this litigation, which is a significant issue. But ultimately, I don't see any significant prejudice. It'll be his choice whether or not he appeals. But in resetting a real hearing in this matter, the hearing on the merits, I want to set it now on a time frame which allows Mr. Hupy to conduct further discovery or discovery itself, if he needs that, to now file amended briefs, and then to set a hearing date that also would be timely. He is entitled to a timely hearing. We talked about that at the last hearing, and that was one of his arguments and concerns if the court did not strike the answer. And so, Mr. Thomas, if you believe that you would be conducting discovery, about how long do you believe that you would need to effectuate that discovery and then file an amended opening brief?
Well, before we even get into discovery, Your Honor, Mr. Hupy's going to need to file a motion for clarification with this court about this court's last week's ruling in order to go forward, like I just said, about which mandatory court rules are necessary for Mr. Hupy to know which court rules that he needs to follow and which ones he doesn't, the mandatory court rules, like CR 12A4 and
Mr.
CR
Thomas,
18.
I can tell you the court rules apply whether or not there's been substantial compliance with the court rule and how the court rules on a particular issue. The civil rules apply to this proceeding. I know you disagree with my ruling and you believe that I did not properly interpret the rules and the law, and that certainly can be an issue that Mr. Hupy continues to raise at further proceedings. I've never said the civil rules don't apply. They do apply. There's no confusion. And so now me articulating that on the record, if you don't want the court to set another hearing, I won't, but there needs to be a hearing on the merits. I presume Mr. Hupy would like a hearing on the merits. He's indicated by way of you that you need further discovery, and so I'm asking you the time frame so that that can be set forth and we can get a new hearing date.
Then Mr. Hupy would like to request sanctions again because he's going to have to go back and redo his opening brief and his reply brief in this matter, where Lewis County admitted that as a matter of deliberate strategy, it withheld its answer, and it even admitted in the argument today that it's not really even necessary for the issues.
So I'm not taking up that issue. I ruled on all issues last week, and so I'm asking again about how far out you would like the hearing on the merits set that could take into account the fact that you would like to conduct discovery.
2 months. So just for clarification, is this court reconsidering its decision last week to grant the certified appeal then?
I've already indicated that I misunderstood what you were requesting and that I clarified that today by asking the questions that I asked and then indicating that I misunderstood that it was actually a request that I certify that I think there's this major issue that has to be decided before the case can be concluded. I don't find that, and so I don't know that it's a reconsideration more than a clarification because the court misunderstood your request, Mr. Thomas, at the conclusion of the hearing yesterday. So about 2 months would be July 20th. So do you want the 20th or the 27th, or do you want to go into the first part of August? I do believe I'm gone a couple of Fridays in August, so the end of July would probably be better, but I'll hear from you about, because there are holidays, you know, there's the July 4th holiday in there. I don't know if that impacts you or if you have any time off scheduled for the summer.
July 20th would be preferable.
All right, so I will set the hearing on the merits for July 20th at 9 a.m.
And then will all briefing be redone?
Well, I believe that you wanted to file a different brief.
Okay.
You don't have to file a different brief. I could rely upon what you already have, but my understanding was that based upon the answer filed by the defendant, you believe that there were some issues that Mr. Hupy had not properly addressed.
Okay.
And so if you don't need to file a new brief, you don't have to. But certainly the briefing requirements, it has to be filed at least 28 days prior to the hearing. The briefing schedule is consistent with the rules for summary judgment as it relates to when the briefs are due.
Okay.
All right, thank you.
Thank you.
Thank you.